Hello, everyone, and welcome to Uncivil Law. As always, I hope you're having a great day, and we are here with an order signed by a federal judge that issued a temporary restraining order against the police of Denver as it relates to less than lethal force, such as rubber bullet projectiles and tear gas. And we've also have a motion from the police to modify. But before we get into that, I'm just going to quote you from the Denver Police Department from their tweets. Now, I'm not sure why they tweeted this today. They tweeted this about an hour ago, maybe a little bit more than that. No, 16 hours ago. But here's what they said. They said a federal judge issued a temporary restraining order, TRO, clarifying the Denver Police Department use of non-lethal disperant devices. In the meantime, we will comply with the judge's directions, many of which are in line with our community consulted usage of force policy, but not necessarily all. Many of them, some number of them, not necessarily all. And then they also said in a tweet, we are asking for modifications to the order that would account for the limitations on staffing and body-worn cameras so the directions can be operationalized. Again, not so much directions as order. And operationalize them, or don't do anything, because you are now bound by a court order. That is what an order does. Very exciting. So we're going to read this TRO, temporary restraining order, and the judge's findings, and we will read the police's request to modify. And this order came down yesterday at 8:40 something p.m. local time, and their attorneys managed to file a response that same day, which is pretty epic work, to be quite honest. So I don't know if they got an advance notice or something before the TRO went live, but that's pretty fast to do a turnaround. I mean, that's less than 3 hours to write up a response. That's pretty fast. So I'm not sure about that. Anyways, let's read this thing and figure out what is going on in this, and we will just go from there. Why are people texting me? Can I do a FaceTime now? I cannot. Hold on. My dad is texting me. I have to text him back. Hold on 1 second, please. Just started streaming on YouTube. Smiley face. Okay, great. Dad takes priority over you guys. Even though I love you all. All right. So we have the order from the judge, and we're going to read this. Yeah, let's not look too let's let look too hard into that. All right. Order on plaintiff's motion for a temporary restraining order. All right. So procedurally, we'll just do a little bit of background here. A temporary restraining order or a preliminary injunction are technically the same. The TRO is usually without the other side responding, where it can be. It's a lot faster. It's to deal with an immediate situation. They're very unusual to grant, just generally. They're more common in domestic violence situations, but sort of uncommon in general. A preliminary injunction is a little bit more common, but still both are considered equitable remedies. You're not entitled to either one as a matter of law. So the judge is going to get into this. There's a 4-part test you have to prove, likelihood of win, the balance of equities, and all the nature of the damage is going to result, and so forth and so on. So it's a little bit unusual to do a TRO, but he did a TRO, and it's even more unusual to do one against the police. So that's the thing that happened. All right. This matter is before the court on plaintiffs Agazi Abe, Gabriel Thorne, Amy Schneider, and Michael McDaniel's request for a temporary restraining order to enjoin, which is to stop, prevent, bar, the defendant, city and county of Denver, specifically the Denver Police Department and police officers from other local jurisdictions from whom Denver has requested assistance in response to protests that have arisen following the George Floyd incident in Minneapolis, from using chemical agents or certain physical force against individuals engaged in demonstration activities, documentation of the demonstration and police activities, or in the treatment of injured demonstrators. So we want to prevent use of force against people engaged in demonstration, people who are documenting it, media or otherwise, and people who are attempting to treat those who have been injured. All right, so that's what we want. For reasons stated herein, the motion is granted in part. Hold on. Okay, yeah, anyways. On May the 28th, 2020, citizens of Denver, Colorado joined a nationwide expression of outrage at the death of George Floyd and other acts of violence perpetrated by police officers against the African American community. Though much of the demonstrations have remained peaceful, violence and destructions have occurred at the hands of citizens and police officers alike. Not sure I necessarily would put the phrasing that way. Violence and destruction has occurred at the hands of the police. I'm not sure I'd phrase it that way, but violence more appropriate, but destruction, I don't know. Anyways, depends what you classify as destruction, I suppose, but it's a little bit, it's not quite the same thing. Plaintiffs challenged the Denver Police Department use of chemical agents, including mace, some kind of spray, which I'm not going to attempt, or mist pepper spray, pepper gas, tear gas, skunk, inert smoke, pepper pellets, and xylyl bromide. Hopefully I got that something close to correct. And rubber projectiles on protesters participating in the demonstrations. Plaintiffs sue on behalf of themselves and similarly situated individuals, alleging that during these demonstrations, the Denver police have, in some instances, violated their First Amendment right to freedom of speech and the Fourth Amendment right against excessive force by using pepper spray, pepper balls, rubber bullets, flashbang grenades, and tear gas to punish plaintiffs for demonstrating against police brutality. Well, this would be your correct theory of the case, right? Fourth Amendment, excess force, that's it all day long, and we're doing it for First Amendment reasons, or purportedly First Amendment reasons, protected speech. So we can't use, in general, force to disperse people who are engaged in lawful speech. Query specific examples. For example, the president trying to go to the church, whether or not that might fall into some sort of exception that we'd have to analyze separately. But yes, just for the heck of it, no, not normally. All right, so good times there. We haven't quite gotten to no smoke, no pepper spray. We're just so far in the beginning of the case. We haven't gotten to the conclusion, Isaac. So, just slow your roll a little bit. We haven't got that far along yet. Slow your roll. We're just setting things up. We haven't gone to and this is what we're doing. So, just a little bit early on that one. The court has reviewed video evidence of numerous incidents in which officers used pepper spray on individual demonstrators who appeared to be standing peacefully, some of whom were speaking or yelling at the officers, none of whom appeared to be engaging in violence or destructive behavior. Well, that would be helpful, right? Now, you'd want to know some other things beyond what is just being here, like, for example, were they attempting to spray someone who is right next to them, or someone behind them, or other things. But they have reviewed tape of instances in which this is occurring. So what else the tape might show, unclear, but we have some instances, something we can adjudicate against. The plaintiffs cite video evidence of officers using projectile on several journalists in the process of documenting the scene. And I did see that one in DC where there was a reportful demonstrators, in some cases resulting in facial fractures, in some cases resulting in permanent loss of vision. Yeah, I don't know if that was Denver or not, but I know at least one reporter has lost an eye. So I guess invested in safety goggles or something, I don't know. Finally, plaintiffs cite video evidence of 3 instances in which officers threw tear gas or shot pepper balls into peaceful crowds. Okay. Plaintiffs allege defendants' use of such force has resulted in injuries including loss of vision, fractured bones requiring surgery, deep lacerations, loss of eyes, and ruptured testicles. That's horrible. They further allege the officers have targeted peaceful protesters, journalists, and protest medics, and have retaliated against demonstrators for engaging in demonstrations and sometimes for expressing anti-law enforcement views, presumably. Plaintiffs allege that this use of force against peaceful protesters and others is sometimes intentional, and that the officers target projectiles at the demonstrators' heads and groin. To the extent that it is intentional, that they are purposely trying to target peaceful people with this level of force, that does seem unconstitutional and excessive. You can't use force against peaceful protesters without more. You need a little bit more. And so, yeah, that seems excessive. So we have a procedural background. We filed this complaint on June the 4th, so that would be the day before this was granted, which is, again, pretty typical for a TRO. TROs can be very fast. They are specifically designed to be fast. They're designed to fix a problem that exists like right now. So yeah, TRO, same day, hours can happen sometimes. So next day for TRO, not atypical. It's also a little bit why judges are hesitant to use them, because they come so early in the process. They're a very quick mechanism, and they're very fast and efficient, and they're usually without full briefing and things. So judges tend to be a little bit hesitant to use them. It's a big club, so you want to use it judiciously. So the plaintiffs filed a complaint in the district court. The defendants, which is the police, removed it to the federal court. Federal cause of action? I'm not sure what their basis to remove it is. Interesting. So the plaintiffs filed it in state court. The defendants, the government, moves to remove it to federal court. What is the basis to remove it? Which is a fancy way of saying transfer it. It's not diversity jurisdiction, presumably, because presumably they're Denver residents or Colorado residents, so it's not diversity. And it wouldn't be pled as a federal cause of action. It might be if they were federal people that were doing it, if they were federal law enforcement that was doing it, you could remove it that way. But what is the basis to remove this? I'm not sure, but they did. The plaintiffs could have filed this in federal court in the first instance. That's what's confusing me. The plaintiffs could have filed this in federal court because the plaintiffs have a federal cause of action, but they chose to file it in state court. So how are the defendants transferring it to federal court? That's what's confusing me a little bit. The plaintiffs' alleged defendants violated the Fourth Amendment right against excessive force. The plaintiffs' alleged defendant violated their First Amendment right to freedom of speech. The parties heard this motion in an emergency oral argument for the TRO on June the 5th at 6 p.m. And then they issued it about 3 hours later. So, pretty fast. In determining whether to grant the temporary restraining order, the court must analyze four factors: whether the movement will have a substantial likelihood, whether irreparable harm will ensure if the request... I've lost my live stream chat. That's always good. Whether irreparable harm will ensue, whether the threat and injury outweighs that harm, and whether, if issued, the TRO will not adversely affect the public interest. Matt, can you see if you can find for me what the basis to remove it was to federal court? I'd appreciate it. Can you see if you can find in an earlier document what the basis is? Because it doesn't look like they're going to discuss it here, and I'm curious. All right, so analysis. Likelihood of success on the merits. In cases in which the deprivation of constitutional rights is at issue, the likelihood of success on the merits is determinative. Before turning to these issues, however, I wish to make certain things perfectly clear, as I did during the hearing held this evening. First, people have an absolute right to protest and protest the actions of government officials, including police officers. I wouldn't phrase it as an absolute right. I'd phrase it as a fundamental right, because if it were truly an absolute right, then it couldn't be taken away in any degree. And we know that's not true. We know time, place, manner restrictions, and we know a whole bunch of other things. So it can't be an absolute right. So the judge is using a word here he really shouldn't use. It is one of the many freedoms on which this country is built. Second, police have a very difficult and often thankless job. They are frequently called upon to make split-second decisions and to expose themselves to danger while protecting the health and safety for us all. Third, some of the behaviors of which I hope and believe are a minority of police officers in Denver and the nation during recent days and before, not only vis-a-vis people of color, but against peaceful protesters of all backgrounds, have been discussing. $20 from El Rojo Grande, saying I'm number one. Thank you, El Rojo Grande. Your support is extremely appreciated, and I love your banner. It is extremely cute and appreciated. Thank you. Finally, as I emphasized during the hearing, the difficulty in trying to draw enforceable lines that permit police officers to use appropriate means to respond to violence and destruction of property without crossing the line into chilling freedom of speech and abusing those who wish to exercise it. I analyze the likelihood of success of each of the plaintiff's claims. So the judge says here that this is a problem. It is a problem. We want to make sure that people have the freedom of speech. We want to stop people from rioting, looting, burning things down, behaving violently, so forth and so on. And some of these places are happening in the same place at the same time. Thank you for the notice of removal. Let me just, he gave me this very quickly. All right. So notice of removal is pursuant to 28 U.S.C. 1441, except as otherwise expressly provided by an act of Congress. Any civil action brought in the state court of which the district courts of the United States have original jurisdiction, but may be removed by the defendant or defendants to the district court for the district and division embracing the place where such as action. Any civil action brought in state court of which the district courts have original jurisdiction may be removed. Interesting. This court has original jurisdiction under 1331 because it's related to civil actions under the Constitution. This action, therefore, may be removed. Interesting. I either did not know that or I had forgotten that. One of the two. But I've learned something that I either forgot or I didn't know in the first place. So 28 U.S.C. 1441, except as otherwise expressly provided by an act of Congress, any civil action brought in a state court of which the district courts of the United States have original jurisdiction may be removed by the defendant. So any civil action in which a district court had original jurisdiction may be removed. So if the plaintiff can do it, the defendant can do it. Interesting. I did not know that. Okay. Excellent. I've learned something. Very exciting. Let's move back. So now I know why this isn't federal court. Because there's a section that says I can do that. Cool. Very, very interesting. Learning is fun. The Fourth Amendment guarantees the right to be free from excessive force. Excessive force claims are analyzed under objective reasonable standardness of the Fourth Amendment. The reasonableness of an officer's conduct must be assessed from the perspective of a reasonable officer on the scene, recognizing the fact that an officer may be forced to make split-second judgments under stressful and dangerous conditions. The Fourth Amendment standard requires inquiry into factual circumstances of every case. Relevant factors include the severity of the crime, the potential threat posed by the suspect of the officer's safety, and the suspect's attempt to resist or evade arrest, but presumably not escape. Yeah. And thank you, Matt, for helping me look that up. I appreciate that very, very much. Here, plaintiffs provide video evidence of police conduct at the demonstrations. Those videos show the officers had ample time for reflection and were not dealing with the dangerous conditions. Named plaintiffs were attacked with rubber bullets, tear gas, allegedly solely on the basis of their presence at the demonstration, their viewpoint, which is a big constitutional no-no. You can't do that. You cannot discriminate on viewpoint. That is a no. You can't do that. Or their attempts to render aid to injured people. Additionally, plaintiffs allege the officers specifically aimed at their heads and groins, causing these injuries. Good. These are peaceful demonstrators, journalists, and medics who have been targeted with extreme tactics meant to suppress riots and not to suppress demonstrators. Will everyone on chat please give an @Matthew Lago and just say thank you, Matt, for being awesome? Well, please, will everyone in chat please give an @Matthew Lago and just say thank you, Matt, for being awesome and helping Blackleaf. You are the man. Show some love to Matt. He's a good guy. Thank you. There may be later questions of qualified immunity to grapple with. But the plaintiffs have established a strong likelihood the defendant engaged in excessive force contrary to the Fourth Amendment. Yeah, the QI for the liability issue, we all know that all too well. But the QI isn't going to solve them from an ongoing thing. So we can do something about things in the future. Remedies for the past are a whole nother set of problems. But we can do something about it going forward, at least. So good times had that. Yeah. The plaintiff's First Amendment claim. The First Amendment provides that all citizens have a right to hold and express their personal political beliefs. Organized political protest is a form of classically political speech. Yes, in our tier of constitutional rights and First Amendment rights, assuming that you believe in such concepts, but assuming you believe in such concepts as tiers of speech, at the very top of this is political speech. So that is the most protected form of speech. So among all the things you could be talking about, political speech is the most protected for very obvious reasons. So assuming you believe that some free speech is more equal than others, assuming you believe that some free speech is more equal than others, then political speech is the most equal of them all and gets the most protection for very obvious reasons. So we have inherently political speech, and we have viewpoint-based discrimination. And this triggers just all your constitutional bingo cards. Just all kinds of no, you can't do that. The First Amendment safeguards an individual's right to participate in a public debate through political expression and political association. This reflects a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, and the Supreme Court has constantly commented on the central importance of protecting speech on public issues. Thus, the courts must scrutinize carefully any restrictions on public issue picketing, or just political speech at large, but yes. Additionally, the Supreme Court has repeatedly held the police may not interfere with orderly, nonviolent protests merely because they disagree with the speech, or because they simply fear a possible disorder. You can say mean things to the police. We covered this recently. It's okay to flip off the police. It's okay to say mean things about the police. It is not okay, for example, to throw bottles at the police or burn things or paint with spray paint, walls, or burn down cars, or break into places, or rob them, or cause destruction and mayhem. These would be not legal things. But yes, the police cannot come after you simply because you're saying mean things about the police. One would imagine that if someone wants to have the police are awesome rally, the police are not going to respond the same way. And that's a bit of a problem. Yeah. Yeah. I love that what Melody says, 16040. But Blackleaf, it wasn't clearly established constitutional right. An officer couldn't fire rubber bullets at a protesters' face. Therefore, Melody gets a point. +1 for Melanie for making me laugh at the horror show. Good times. It has long been established the First Amendment bars retaliation for protected speech and protected association. The 10th Circuit examines First Amendment retaliation claims under some case, which were $10 from Willie Czar. Say something bad about the cops, lose an eye or a ball. Bad. Is that it? Something like that, yes. Something like that, yes. Apparently, you now need to wear safety glasses and a cup when going to a protest. Yeesh. The 10th Circuit examines First Amendment retaliation claims under some case, which requires inquiry into whether the plaintiffs were engaged in protected activity. Defendants caused the plaintiffs to suffer an injury that would chill a person of ordinary firmness from continuing to engage, and they're motivated by that action. And without looking at the case law in any other circuit, I would imagine that every circuit has a case that says roughly the same thing, more or less, because that sounds pretty basic. Here, first, plaintiffs were engaged in constitutionally protected activity through an organized political protest. Second, defendants' use of excessive force likely caused the injury sufficient to chill a person of ordinary firmness from continuing to engage. Officers used physical weapons and chemical agents to prevent not just peaceful demonstration, but also the media's ability to document the demonstrators and plaintiffs and third parties' ability to offer demonstrators. I take mild exception, personally, at treating the media as special, because I don't think they're special. But this court seems to want to treat them as special, but that's okay. Anyways, Peaceful demonstrators' legitimate and credible fear of police retaliation is silencing their political speech, the very speech most highly protected under the First Amendment. Yeah. Third, it also seems likely defendants' actions were motivated by the content of the demonstrations against the violence. Citizens should never have to fear peaceful protests on the basis of police retaliation, especially when not they're protesting the very violence. That's cute and a very, very fair point. I take that as true. As with the plan's Fourth Amendment claims, there may later be questions of qualified immunity. I'm sure the qualified immunity cases on this should be pretty interesting. I think if memory serves correctly, the Supreme Court on Monday is having a should we grant cert session day, and I believe there are 4 or 5 cases on QI that are currently up for consideration on Monday. Query whether or not the United States Supreme Court may be increasingly enhanced to grant cert in one of these QI cases. I really hope the answer to that question is yes. Now would be just fine, Supreme Court. Irreparable harm. The Supreme Court has made clear that loss of First Amendment freedoms for even minimal periods of time unquestionably constitutes an injury. The demonstrations in Denver are ongoing, likely even as this opinion is written. Yeah, probably true. The demonstrators will likely continue tonight, and at least into the weekend. If immediate relief is not granted, the speech will be chilled and outright denied over the next several days or weeks of demonstrations. Indeed, irreparable harm has already occurred in the form of physical injury and suppression of speech. There is no reason such harm would not otherwise continue if this relief were denied. Officers will continue to use force, secure in the knowledge that retrospective claims take a significant amount of time, energy, and money to pursue, and of course, more importantly to everyone, say it with me here, qualified immunity. It would be so wonderful if the Supreme Court took their qualified immunity away and all these things suddenly became exposed to the liability for it, which you can do because it's civil, not criminal. So ex post facto doesn't apply. Oops. So that'd be great. Oh, I'm gonna be fine. I have qualified immunity. The Supreme Court says no. Uh-oh. That'd be great. I love to see that happen so much. Yeah, no, your QI is dead. It's dead retroactively. Suck it. Significantly, plaintiffs also note that speech is deeply rooted in the current time and context. I recognize the importance of shielding and uplifting this ongoing nationwide movement. Okay. As such, I find irreparable harm will occur if I deny relief. Balancing harm to the non-movement. Yeah, well, these are. I tell you what, the longer things go on, the more and more I'm like, maybe we should just abolish qualified immunity. I've talked about this before, my own hesitations on this, because again, it's a conservative trait, and one of the things conservatives do is they like the status quo, even if they want to change the status quo, and they're always concerned about it, right? So it's a tempered reaction. So my own reaction has been, yeah, maybe we should do something about qualified immunity. But the more and more this goes on, the more and more I see stuff that's happening. And the more and more I see some of these videos that have happened. For example, the police pushing that elderly guy down to the ground. And then 50 of his fellow cops resigning because did you see this? Did you see this crap? So this elderly guy is pushed down to the ground. The 2 cops who did it are suspended. And then 50 of his fellow cops quit in protest, not over the pushing down. They quit in protest over the suspension. So yeah, the longer this goes on and the more stuff I see, the more I'm like, yeah, maybe it's time to pull that abolish qualified immunity trigger. Maybe it's time to pull that pull that abolish qualified immunity trigger. Yeah. Anyways, Plaintiff's motion does not discuss potential harm to the defendant. In theory, the inability to use the complainant tactics limits the officer's ability to protect themselves against potential violence. Yet this hypothetical harm, especially given the fact the officers have access to many other types of non-lethal weapons that they use on a daily basis, including tasers. Yeah, I've suggested some alternative remedies to killing QI, but still I'm more like, Yeah, maybe it's time to kill QI. Yeah, I'm thinking about it. The unlikelihood of such harm to the officers is outweighed by the very real harm caused to the plaintiff, the public interest. The 10th Circuit has recognized it's always in the public interest to prevent the violation of a constitutional right. It sure would be. Thank you for taking notice. The 10th Circuit has particularly recognized a strong public interest in protecting the First Amendment. Yes, even where individual constitutional rights come into conflict with other important objectives, the 10th Circuit has always held these other values must yield to the protection of the individual. For example, in some case, the 10th Circuit held that while a public has an interest in the will of the voters being carried out, the public has a more profound and long-term interest in upholding an individual's rights. Yeah, we value democracy, we value the will of the majority, but we don't rule it. We don't value it more than rights. So yes, while it will frustrate the ability of people to have their political will done, that was kind of the point. Yes, it will frustrate your will. You can't have your unconstitutional law. That was the idea. So yeah. So yes, we must uphold the rights of the individual, even though it goes in the face of the majority, or more to the point, the police in this particular moment. Oh, they only resigned from the riot squad, not their jobs. Well, still, either way, it still is equally like whatever. I don't know how much better or worse that is, but noted. They only resigned from the riot squad, not their jobs. Okay. I know. I'm not sure how much that matters one way or another, to be quite honest. So yeah, they only resigned from the riot squad so that because they objected to one of their police officers being suspended. So presumably they are upset that they do not have the freedom or the latitude to push a elderly person to the ground. Okay. All right. But they still want to be cops. Okay. Here is clearly in the public interest to protect the right to demonstrate, the media's ability to document that demonstration, and third parties' ability to render aid. Plaintiff's lawsuit itself is a class action based on all other people similarly situated. Plaintiffs do not expressly discuss the potential harm to the public interest. The most likely potential harm is an increase in property damage. Fair. Although I do not agree. I heard they resigned because the union said they wouldn't cover legal fees. They resigned because no one is footing the bill for them to be bullies. I again, yeah, we won't cover your legal fees if you push an unarmed elderly man to the ground and he cracks his head on the skull. And as I point out, I've had an uncle die from that, so I'm a little sensitive to that. Although I do not agree with those who have committed property damage during the protest, property damage is a small price to pay for constitutional rights, especially the constitutional right to speak against widespread injustice. I don't know. I can't quite get behind that phrasing, and I do take a bit of exception to this idea that property damage doesn't really matter. Not for at least the reasons that a lot of insurance companies have a clause in their insurance that says we won't pay for civil unrest such as this. So a lot of these things may not be covered by insurance. And a lot of these places that are being harmed are minority owned because they're in downtown communities, and a lot of minorities own places in downtown communities. So I take some exception to the idea that property rights are unimportant or they don't really matter or they are just not valuable. So I don't really like this phrasing here. If a store's windows must be broken to protect a protester's facial bones from being broken, that is a more than fair trade. Again, I don't quite agree with that. I don't quite agree with this phrasing. I can't quite get behind this idea. We should definitely protect the protester's right to protest, and we should definitely protect the property against the looters and the anarchists, of which there are several. Now, trying to figure out who that is on the fly is difficult, but I can't quite get behind this idea that, well, if a store window is broken, if it means a protester doesn't get shot in the face, well, that's okay. I mean, I don't quite get there because it's trivializing the legitimate property interest. Like that guy who has since been compensated because he was able to raise money on GoFundMe. But that guy who was like a firefighter who had just built his dream restaurant, had it open for business, and they burned it to the ground. And it's like all his money is gone. There's real lives, real things behind this. I mean, it's real people's lives, real people's livelihood. And to treat property rights as trivial is a little bothersome. I can believe in two things at the exact same time. Watch me walk and chew gum at the same time. I believe in a protester's right to protest. I believe that you should secure people's private property. Yeah. 20 pounds from Aluminum Tech. Could you cover City of Los Angeles versus Lions? Yes, I can. I will add it to the list. Thank you very much. And thank you for appreciating what I do and what I put out. It does mean a lot to me that I have the support because, it means people value what I'm doing. So I appreciate that. So I'll just go over law review stories and put it in there before I forget. And now it's on the list. Anytime, Google. Thank you. Great. All right, back to the live stream. I don't know if elderly emotional qualifiers. I don't know if saying elderly is emotional qualifiers a factual element. But anyways, I'm not quite sure what I was saying, but it's a little hard to keep track of multiple things at the same time sometimes. Anyways, where was I? Okay. The threat to physical safety and free speech outweigh the threat to property. I don't know about that. Yes, please thumbs up if you've not already done so. Please like the stream. I do this for you. It is always appreciated. Help me grow. Help the YouTube algorithm find me and all that good stuff. Conclusion. In issuing this relief, I do not seek to prevent officers from protecting themselves or the community. I seek to balance the constitutional rights against the officers' ability to do their job. However, the time has passed to rely solely on good faith and discretion of the Denver Police Department and colleagues from other jurisdictions. Ouch. I believe everything that Commander Felon testified during the hearing last night about the duty of police to protect the rights of citizens who demonstrate protest. However, they failed in that duty to police its own. Ouch. Ouch. You gotta help YouTube. You gotta help YouTube realize that we need censoring. Thanks. That's great, Valerie. That's super helpful. Thanks. Order. A plan's motion for temporary restraining order is granted in part. The court temporarily enjoins the city and county of Denver $5 from Nuvi. Thank you very much. The court temporarily enjoins the city and county of Denver, and specifically the Denver Police Department and its officers from other jurisdictions who are assessing the Denver police officers from employing chemical weapons or projectiles of any kind against persons engaged in peaceful protest or demonstration. To better assure this idealistic order is carried out, the court temporarily enjoins the Denver Police Department and officers from other jurisdictions working with the police department from using chemical weapons or projectiles unless an on-scene supervisor with the rank of captain or above specifically authorizes such use of force in response to specific acts of violence or destruction of property that the commanding officer has personally witnessed. Yeah, the offer further orders that kinetic impact projectiles and all other non or less lethal projectiles may never be discharged to target the head, pelvis, or back. These projectiles and all other non or less lethal projectiles shall not be shot indiscriminately into a crowd. Non-Denver officers shall not use any demonstration of force or weapon beyond what Denver itself authorizes for its own officers. Any non-Denver officer permitted to or directed to be deployed to the demonstrators shall be considered an agent of Denver, such that Denver shall ensure the officers is limiting their use of force to the authorized. So Denver, you absorb all that stuff. Congratulations for you. All officers deployed to the demonstrations or engaged in demonstrations must have their body-worn cameras recording at all times, and they may not intentionally obstruct the cameras or recording. Love it. Chemical agents or irritants, including pepper spray and tear gas, may only be used after an order to disperse is issued. Any and all other orders to disperse must be followed by adequate time for the intended audience to comply, and officers must leave safe room for egress, which is to say to leave. If it appears the intended audience was unable to hear the order must be repeated prior to the use of chemical irritants. Yeah, I don't have any major problems with this the way it's written. Seems fine. Seems all good, all fine. So I have no major problems with any of that. I don't know why some of the text is in weird colors, Matt. It just is, and we're just rolling with it. So, we'll just make do. All right. So now the government, the city, is sad, and it files its response the same day. So we'll read its response and see what we think about what the city says about, all this stuff. Certificate of conferral. All right, we attempted to confer, but before this filing, we haven't been able to confer. All right. When final judgment has not been entered, a trial court remains under the power to reconsider or modify its orders. The grounds warranting a motion to reconsider including intervening change in the controlling law, new evidence previously unavailable, and the need to correct clear error or prevent manifest injustice. Which, again, this whole thing was filed 3 hours later, so query which of those apply. Did Viva was Viva thinking about preempting my stream and decided not to? Thank you, Viva. You're the man. I noticed that Viva's up to 250,000 subscribers, man. I'm a little jealous. I'm not gonna lie. I mean, he's been at it a lot longer than me, but I'm at 7,800. So my 10,000 subscriber special should be coming up relatively soon. How exciting! Does that edict address any response if they're firebombed or violently attacked? Is essentially a complete stand-down order? No. It says that a captain can do it if they see it with their own eyes, and then can. I mean, yeah, they can direct it if but they can't fire wildly into a crowd. We read all that. A motion to reconsider does not serve to allow a party merely to re-argue an issue previously addressed. Sounds suspiciously like what we're doing. When the re-argument merely advances new arguments or supporting facts which were available at the time of the original argument. However, when a motion clearly demonstrates a manifest error or presents newly discovered evidence, it's appropriate. These circumstances are present here. Okay, I'd love to know how you're going to come up with something in this interval that's going to be, the court missed the ball. This will be entertaining. No, only mods can post links here. Sorry. It's not up to me. I don't think I have the ability to change that. I think it's in YouTube somewhere. Only the mods can do that. As far as I know, I can't even authorize it. But yeah. The court entered these TRO shortly before 9 p.m. on Friday after a brief hearing with less than 1 hour notice, and the requirement of submiss proposal or not later than 7:30, less than 1 hour after a brief hearing continued, which for a TRO is not unheard of. Yes, you have to move fast for a TRO. And it's also why they're rare. But yes, they gave you very little notice. You had your hearing. Sometimes they'll even do TROs without a hearing. They'll do ex-parte TROs. It's not even unheard of to do that. So yeah, they gave you a hearing. They gave you notice. They had the ability, and you're very sad that you didn't have more time. How much time were you giving the protesters you were firing on? That's what I want to know, right? The parties were not permitted to present evidence during the hearing, which is to say documents or witnesses or stuff, which again, for a TRO, is not unusual for a TRO. It's supposed to be very clear. We saw some videos, it's very clear for a TRO. Instead, the court only posed questions, and the questions did not encompass several limitations imposed by the court. Okay? As a result, Denver did not have the opportunity to explain to the court while certain restrictions might propose substantive challenge or might not be able to be complied with. Sucks to be you, unfortunately, leaving officers with the inability to defend themselves in order from unlawful aggressors infiltrating protest activities. In fact, the court's orders restricts the ability of Denver police departments to use specific types of force, includes the requirement, for 10 K subscribers, cover Vic Mignogna and Arbery in the same video just to watch the internet burn. That'd be good. Good times. Yeah. I'm still borrowing Leonard's Discord for the moment. In fact, the court's ability restrict the ability of Denver Police Department to use specific types of force and includes the requirement that the Denver Police Department and all other law enforcement agencies who have responded to assist the Denver Police Department to refrain from or limit specific type of force used to protect officers and protesters alike from assault of contract of aggressors, as well as to protect the destruction of public or private property by individuals who are not present to engage in peaceful protesting. Denver respectfully requests this court consider its motion and modify its order to address two of the most troubling aspects. Without these requested modifications, of which Denver would have explained had given the opportunity, yeah, it's just a little bit. Schadenfreude is really the only word for it. The Schadenfreude is very, very real, because the government, I assure you, has been to court many times on a TRO and gotten orders against people who were sad, and they said, "Well, sucks to be you." And now that they're on the wrong side of the TRO, but they're like, "But that's not fair, though. That's not fair, because we didn't have a full opportunity. We're on the wrong side of the TRO." The Schadenfreude is very, very real, my friends. It is very, very real. So if you're wondering why I'm not as sympathetic to this as you might expect, it's because Schadenfreude. Yeah. Without these requested opportunities, which we would have explained if you'd given us the opportunity, the safety of these people may be compromised. Therefore, they respectfully request that you modify this order based upon the following. My percentage stats is better than Viva's? Great. Excellent. I'm not 100% sure what that means, but great. Thanks. Denver first requests that Viva's also ranking it in recently on his live streams. I don't know how much he's making on his live streams, but it seems like he's making some bank on his live streams. I'm doing okay. I guess I'm doing okay for my people, but man, do I want $2,000 a live stream? Yes, I do. Yes, I want $2,000 a live stream, because I feel like that's about what he's getting. I don't know. I haven't actually done the math, but he's doing pretty well these days with the live stream, with the super chats. He's getting them so fast, he literally can't read them fast. That's how fast they're coming in. He's getting so many, he can't keep up with them. I'm a little jealous. I'm a little bit coveting my neighbor over here. I still love Viva, though. He's a great guy. But, still a little jealous. Because it's yeah. But I just remind myself the right metric is be better than who you were yesterday, not be better than someone else is today. So Viva is the wrong metric. The right metric is who I was yesterday. And I'm getting better all the time with you. Thank you so much. I appreciate it. I can't give you $2,000, but here's two. Thank you, Phoenix. It is appreciated. Thank you. Denver first requests the court modify the provisions that temporarily enjoins the Denver Police Department and others from the jurisdictions that work with the Denver Police Department from using chemical weapons or projections unless an on-scene supervisor at the rank of captain or above specifically authorizes the use of force in response to specific acts of destruction. This is not feasible under the command structure of the Denver Police Department because currently there are only 4 police officers with the rank of captain and 1 commander responsible for the downtown others. Other commanders are also responsible for their assigned districts. Okay, so you have 5 people who could presumably authorize this, or the chief of police or other people, but yeah. So you have only 5 people in this district who could authorize it. Therefore, the department needs the ability to utilize its lieutenants, which anytime you're talking about police action and you use the word lieutenants, it just makes my skin crawl. S. Jar Jar Binks says, "Can the state simply not comply and claim sovereignty?" No, no. That would be epic, and no. The court will hold the government in contempt. It has definitely happened. So no, they absolutely need to comply. If they don't, the court will destroy them, and the Court of Appeals will destroy them, and the Supreme Court will destroy them. The courts do not like having their authority. Yeah, the courts are the ones saying, "Respect my authority." Cartman in his police uniform on his big wheel rolling around says, "Respect my authority." And then the court's like, "No, respect my authority." Yeah. Therefore, the Denver Police Department needs to utilize its lieutenants who also have command rank to ensure that accountability authorizations are reasonable and necessary force, maybe made when necessary. Without this ability, officers would not receive the immediate direction they may need. When faced with dangerous circumstances, it will not be able to protect themselves or others. Well, they have other means other than those, which the court point out. These aren't your only means. These are just the ones we're excluding. These projectiles and this pepper spray stuff. You have tasers and you have other options, and riot spills and batons and other things. So you have other options. You could use water hoses, like the South. Yeah, use water hoses on the protesters. Circa 1960, Montgomery style. Use water hoses on the protesters. I hear that's super popular. Go with that. During the hearing today, the court asked counsel for Denver only with the highest level of police department command staff was on the street during the protest and was informed that the rank of commander. And the explanation the rank of captain was below commander and above lieutenant. There was $2 from S. Jar Jar Binks. What about enacted full emergency powers and suspend? No. I'm going to go with no. I'm going to go with no. You can't do that. No. The courts can in fact meet. You can't just say the courts can't meet. No. The courts will eat you alive. $20 from Django Fett. I know the appeal is still pending, but could you do the district court's ruling in National Coalition for Men versus Selective Service? Yes, I can. I will be happy to. Your call for your $20. Do you really want me to do the district court's ruling, or would you prefer that I do the oral argument, assuming I can find it? I think that would be interesting. So your call for your $20. Would you like to? I'll put the district court in, but if you'd rather have the oral argument from the Fifth Circuit or whatever it is, I think that'd be an interesting one. Your call. But yes, I will be happy to do one of those. I'll put down as the district court because that's what you asked for until you change your mind. Anyways, where was I? There was no discussion about this information in the context of approving specific types of force by those command officers or personnel observation on the underlying use of force. If there had been, Commander Flynn was available to assist the court in understanding this matter, so his order would have been more fully informed. Moreover, and more critically, there was no discussion or reason counsel for Denver would have inferred discussion was necessary. Of the limited staffing levels, these ranks would preclude Denver from being able to comply with the unrequested relief entered in the order. Oops. Accordingly, you guys do understand that I wasn't actually serious about the water thing. I was making a point by saying, why don't you just bring out the water jet circa Alabama 1960s? You do understand I wasn't saying that was a good idea. I was mocking them. But, yeah. We're a long way from martial law, too. The courts can still meet, but yeah, that's fine. Thanks, Esther Durbings, from your $2 Canadian dollars. Canadian dollars are maple leaf dollars. They are appreciated. Accordingly, Denver now asks the court to modify its obligation under the order to permit officers of the rank of lieutenant to authorize deployment of chemical agents or projectiles in response to specific acts of violence or destruction of property that they have witnessed. This will enable the Denver Police Department $20 so I can't decide, so I'll fund both. Fair enough, you get both. See? Plus oral argument. Now you get both. Yay. Which I heard were done at Lafayette Law School. So that would be cool. Yeah. So I hope the audio is available because I haven't looked, but I think it'll be an interesting oral react. So we'll definitely look to do that. And if I can't find the oral for some reason, the oral audio, I'll transcript, and if I can't find that, then I'll do something on the briefing. So I'll definitely do something for you if I can't find it for some reason. So you will not be out of your $20. Okay, so we want to do the lieutenants. This will enable Denver Police Department and others to have willingly come forward to this to assist these protectors with the necessary direction without compromising safety. Query. If Denver is being a little bit, what would be the right phraseology here? A little bit less than fully honest in this language. Because remember how it said a little bit before that it had 4 captains and 1 commander, right? But now it's mentioning again, oh, by the way, we have people from other police jurisdictions. So query, in the paragraphs above, when they were saying, oh, we only have 5 people who could do this, whether they were including people from other jurisdictions who would be of sufficient rank. Because I bet the answer to that question is no. I bet the answer to that question is no. I believe that they. I think I caught Denver in a little tiny fib. I think I caught them in a little tiny fib. Now they didn't, strictly speaking, lie because what they said was true, but I figured it out. Yeah, I figured it out. They lied by omission. It's like, yeah, we only have 4 commanders and 1 captain or whatever. 4 captains and 1 commander. And that's all the people we have. And then, by the way, also, we have other people from those jurisdictions. How about the ranks of those other people from those jurisdictions? You have any captains or commanders in there who might be able to do that for you? No? You don't want to talk about that? Yeah. I think I caught Denver at a little fib. Denver next requests that the court modify the order. $1.99. Russell Russell J. Gould, legit or not, don't know enough to offer an opinion. Sorry. The word is disingenuous. It's something, yeah. Denver next requests the court modify the following provisions order. All officers deployed at the demonstration or engaged must have their body-worn cameras at all time and must not intentionally obstruct the camera. This relief was also not requested, and Denver did not have the ability to present any evidence or argument addressing the ability to comply. Denver respectfully requests the court needs to modify this provision for 2 main reasons. First, Denver requires the aid of other jurisdictions to assist with crowd control for large stage protests such as those currently occurring that require more officers than Denver has the ability to assist, especially the number of hours the police officers are working, and not all the jurisdictions have body cameras. As a result, complying with the order regarding body cameras for all law enforcement requires Denver to refuse much needed assistance. Well, is that exactly what was written? All officers deployed must have their body cameras worn. I guess it's a little bit ambiguous whether it's saying that they must have body cameras. So it is technically a little ambiguous in the order. All officers deployed to demonstrations or engaged must have their body worn cameras recording. It's a little ambiguous whether they're required to have them or not. $1.99 from Jim Stellata said, I'm fine with disbanding the police. Start with the ATF. Yeah, fair enough. So it says, as a result, complying with it for all law enforcement requires the refuse much needed assistance. Again, and it's also restricted to those that deployed to demonstrations or engage the demonstrations. So it's not deployed to any periphery policing. So you could have them do that, and there might need to be periphery policing. So you can still not have body cameras as long as you're like not dealing with the demonstrators. So there's that. The ability to use other officers to assist with crowd control and protection of property against agitators, which is not exactly what the court wrote. Assist with crowd control, probably. Protection of property, not necessarily. That's not really the same thing. That's not really being deployed. That's not really being deployed to demonstrations. If you're deployed, no, you see, this is again being disingenuous. So first, there is a slight question here: are they being commanded to have body cameras? It's a little unclear in the language, so I'll give Denver a pass. But as to like these other things, like they can do periphery work. Well, how about the ones that are doing crowd control? Yeah, well, it depends. Is that crowd control in the nature of them being at the demonstration? If it is, then yes. But protecting businesses, no. That's not being deployed to the demonstrations. That's being deployed to protect the businesses. So sure, they don't need body cameras. You can do that. That's disingenuous. You don't need to have them because they're not being deployed to the protest. They're being deployed to protect the businesses. It's a different deployment. So go nuts. As if I were the city attorney, I would have no problem giving them that advice. In other words, if I was city attorney interpreting this order, be like, yeah, you can do that. That's fine. Complying with the order requiring all law enforcement requires them to refuse much needed assistance. The inability, blah, blah, blah. All right. Second, the technical limitations of body cameras prevent constant recording and saving of the video for extremely long durations. The body cameras used by members of the Denver police have two modes, a buffer mode and an event mode. In a buffering mode, the camera continuously loops a video for up to 30 seconds before a recording is started. While buffering, video is recorded. In event mode, the camera begins saving the recorded audio and continues to record it, both them pursuant to policy. All officers have required to place the body camera in event mode during various types of incidents, including any action that becomes adversarial, to ensure that such incidents are captured and recorded. I'm guessing that has not exactly happened in all the cases. I'm guessing there has been a little bit of stuff that's not been there. Requiring officers to have their cameras activated in event mode for the duration of protests, many of which last several hours, would shorten the battery life and storage limitations, leaving the functionality inaccessible in later hours of shifts when they may be ignored injury. You can't swap out the batteries or the memory cards or something? Is it really that much a burden? As a result, the requirement for them to have body cameras at all times is not a practical, workable option. Because of these practical limitations and because the plan presented no evidence or hearing suggesting the constant activation of body cameras reduces the number of improper force instances, really, how much evidence do I need? None. Denver respectfully requests the court modify its order. Wherefore, Denver respectfully requests this court enter an emergency motion granting relief to blah, 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 blah. And that's the end of that. So, yeah. Apparently, we have a really hard time changing the batteries, and we have a really hard time swapping out the memory cards. And we only have 4 officers, but we also have other officers we're not going to tell you about. And we can't deploy them to guard businesses without body cameras. Why? I don't know, because the order has nothing to do with that, but apparently that's a problem. So, yeah. Well, they could buy some more batteries, I guess. Yeah. So, yeah, Phoenix. I think Denver's mostly full of it. So, I don't know if what if any additional relief they'll get, but that's what we got right now going on. So that was a super interesting live stream. Just refreshing the chat because it decides to crap out on me every once in a while. There are 125 of you watching and only 65 likes. If you like the stream, please like it. If you like the stream, I will be happy. And thank you for the people super chatting and making it possible for this channel to grow. Thank you for supporting the Hat Fund, because the hat is expensive. So you have paid for part of a hat. It is appreciated. Thank you. $19.99 from James Gary. Thank you. Keep doing what you're doing. You are welcome. It is very much appreciated. Thank you very much. I just want to see the response given. Say you can buy batteries using our Amazon affiliate code. Yeah. Yeah, I don't know, but I feel like some of this is a little BS. And they can do it if they want to. And it does suggest, I mean, because they say, well, you have to have these cameras on anytime you have an interaction. And I'm guessing these cameras have not been on. I'm guessing the police haven't been turning them on. Amazing. It's amazing when that happens. I do love that when you see like video from the field and you see the police rushing to the camera to turn them off. So there's no video of it, so good stuff. Yeah, so we'll see what additional relief that they want to get, but I have no problem in particular with don't fire into crowds, don't fire at people's heads, don't fire at their crotches, don't fire at their backs. Don't use force against people who are not creating a problem. This is all good. And it's a little unusual to see our TRO, but it feels a little warranted, and whether the judge will modify it further, who knows? But we'll see. Yeah, we'll see. Anyways, for the 116 of you who are here, please like the channel if you haven't already, and I'm going to sign out for now. Be good, and you haven't already done so, call your parents. They miss you. Till later, my friends. Cheers and goodbye.